Hey everybody. So another day, another Sarah Boone letter to the judge. And evidently there's problems with lawyer number 7. The honeymoon phase of that is over as he wants to be dismissed from the case. So let's get into these letters. Honorable Judge Kranick. Finally, a new judge. It's strange how the Lord works, as I was just in the process of trying to disqualify Boone after being my judge for 4 years and me still incarcerated with nothing to show other than 7 different attorneys, not by choice. New clips of me walking in and out of the courtroom and everything relative to my case permitted to be slathered on the global internet, and in which I was in the attendance part of my most recent PTC status hearing, which I am trying to ensure my automatic attendance futuristically. Please see my draft motion included. I am still trying to have my attorney submit on my behalf. I wanted to bring to your judicial attention the following information so that you and the world are aware it is not I am ever delaying the trial. It is Wooten inappropriately accused me of doing so in a past hearing, especially now you have mandated a trial date to be had in May, with no further continuances, leaving less than 4 months to put together a complete what should and could have been done already. What happened in all the years prior? Please see all my correspondence online. Now, first she's complaining about no trial, 4 years sitting there, and now she's complaining because they want to have it in May and it's only 4 months to prepare. Make up your damn mind. Continuing. Today, Winston E. Hobson has been my court-appointed attorney for 133 days and counting. And she kind of sort of had to start counting after having 7 lawyers. Okay. To date, Mr. Hobson has only met with me 1 time for a total of 3 hours on November 7th of 23. To date, no phone calls have been received by Mr. Hobson as his phone does not work properly for further, immediate, much-needed communication to be made between client and attorney. To date, I have mailed 5 letters to Mr. Hobson, trying to communicate my urgent need to speak with him. And next page. To date, I sent 1 letter to the investigator in my case to contact Hobson to contact me and see if he can assist in correcting the phone problem. Also to inquire when anyone is coming. To date, I feel I am not included or heard or cared about in my case. Again, from the continued miscommunication again with Mr. Hobson and time-consuming, undiscussed entries are being made on my behalf. The continuance I did not know about. The waiver of appearance I did not know about, along with other documents, and I am never sent copies of anything filed. So I know I keep trying to tell him about no response, furthering the already massive dysfunction in my 4-year case. I was hoping in the PTC status hearing on Tuesday, January 16, 24, I could at least play catch-up in the courtroom. For 5 minutes, so many of my attorneys have done prior, including Mr. Hobson. In the 1 court date I've had for a continuance of a continuance, 10/23 or 10/30/23, to express and emphasize the need for him to communicate and schedule a second very overdue meeting. I still have not even heard from Mr. Hobson about our Ms. PTC status hearing. What's the status? To date, 1 out of 133 days and counting, attorney and his client have met. To date, 3 out of now 3,192 attorneys and client have discussed partial general care information. To date, I still have not seen my discovery. Well, Sarah, you know what's in it. Your Honor, when is the next status hearing, please? Especially since I/we were not at the last PTC status hearing, and especially since I am trying to communicate with my attorney in more than one way to fully maximize and utilize the minute amount of time allotted before the trial. Okay, hold up. First, she's saying it's been 4 years too long, what the hell's going on, da da da. Okay, now she's saying a way to fully maximize and utilize the minute amount of time allotted before trial. Make up your mind, Miss Boone. Which one is it? You don't have enough time? Or it's taking too long? Or you do or you don't? Which one is it? Continuing. My fair, appropriate, lawful trial, ? I still am wondering why, though, I've had to wait for 4 years for something to finally happen in my case. Ask Judge Wooten. I wonder also, was I the oldest case in his docket? Not everything's about you, Sarah. Either way, I'm still here, waiting patiently. I think you mean impatiently. I'm very excited to get this highly anticipated show, quote, on the road. I await your overdue, very needed judicial discretion, supervision, and intervention. Thank you in advance, Judge Kranick. Welcome. So, throughout all the pages, she ends on a backhanded compliment to the judge by saying, I await your overdue and needed judicial direction. Yeah, Sarah, that's going to get you some way. You sound like nothing but a Karen here. And signing off is sincerely, Sarah Boone. Now I have some part of a draft. It says draft on the side. It's still her writing. So it's case number. Okay, so because she's not getting court documents, she's using a notebook and making up her letters to look as if a court document would, so she feels included, I think. Okay, in the Circuit Court of the 9th Judicial Circuit in and for Orange County, Florida, State of Florida Plaintiff versus Sarah Boone Defendant, case number, division, defendant. Okay. Motion to be included in and allowed admittance to all defendants' pretrial conferences and hearings. Comes now, defendant Sarah Boone, by and through her undersigned attorney, Winton E. I can't even read that. Hobson. Respectfully request permittance to attend all of my pretrial conferences and hearings ongoing until the conclusion of my criminal case. Per Rule 3.220, the following is stated to lawfully allow my inclusion, participation, and requested admittance. It's not a movie ticket. The trial court may hold one or more pretrial conferences to consider such matters as will promote a fair and expeditious trial. The defendant must be present at any pretrial conference unless the defendant's presence is waived in writing or on the record by the defendant or by the defendant's counsel with defendant's consent. You give me whiplash here, Sarah Boone. Whiplash. In support, the defendant alleges as follows. The pretrial conferences are for my personal individual criminal case. If professional YouTubers, news channels, court TV, etc. are given permission and allowed to enter into the courtroom for viewing, and the judge also is allowing the conferences to be streamed live without all of the court minutes uploaded to the internet and world, I, the defendant, should be included foremost. Number 2 here. I may not have regular, consistent updates or communication with my court-appointed attorney, and by attending all of my PTCs and hearings, I will know current status, important dates, casework being completed, changes in parties, timeframes, expectations, all pertinent information I, the defendant, have a right to know, want, and need to regarding my case. All information is important, relevant, and necessary to me. Number 3, I am not consistently included in the certificates of service and sent copies of any documents being filed in court regarding my case, as requested numerous times by the defendant in writing and verbally in the courtroom, neither by the judge, the court, or my attorney. By attending my pretrial conference, I will know what documents have been filed, need to be, and will be for my case. Another way I can know what is going on in my case and being worked on. Number 4, and complete overall support. It is my right by law as an individual, defendant, and inmate to be included in any and all developments made in my case. It also is my right to finally achieve success in any and every aspect possible in my case. By attending and being included in my pretrial conference and hearings, said success can and will be accomplished fairly, faster, and promptly. You sound like you're in kindergarten. I want to be included. Okay, continuing. Wherefore the defendant, Sarah Boone, respectfully asked the Honorable Court to grant my motion to be included going forward to all defendants' pretrial conferences and hearings. And then we got it ended with Sarah Boone, the prison address, and then she writes, Certificate of Service. I certify that an original of this document has been filed via U.S. mail with the Clerk of Court of the 9th Judicial Circuit, and that a copy of this documentation will be filed in the Florida e-portal to state attorney and all attorneys and other parties on the case record on this 19th day of January 2024 by Sarah Boone. Jesus, Sarah, do you think because you wrote this letter this way that they just have to make it an official court document? I'm not sure you understand this, Sarah Boone. Just because you read it as if that would have been in a court document doesn't make it an official court document. It doesn't make it... Poor Sarah Boone. Jesus. So as you guys can see, the theatrics are not over. The case is still up in the air based on Sarah Boone's whiplashing theory of not getting enough time to prepare and waiting 4 years for her trial. Whiplash, whiplash, whiplash. So thank you, Miss Sarah Boone, and may the odds be ever in your favor.